3-month extension.
Yes.
And that would be, we would also extend out our date by another 90 days as well, correct?
Correct.
Specifically, do we know what that means by date?
Yes. So for the record, my name is Jason Panos, practicing law at 246 Andover Street, Peabody, Massachusetts. Good evening, members of the board. In answer to the chair's question, it's actually a 91-day extension that would go out to July 3rd, which is a Wednesday. And that would result in a commensurate adjustment to the time in which the board has to close the hearing to November 13th, 2024, also a Wednesday.
Right.
And I attached to my correspondence, Mr. Chair, a status report that was recently submitted to the court that was given to me by our litigation counsel just yesterday.
Okay. Yeah, that was received. Ms. Davis provided it to the board. So we do have access to that information. Thank you.
So I can report, in addition to that, the first of the depositions took place today.
Okay.
And they'll be continuing, I believe, through the end of the month. Now, knowing as little about litigation and procedure, I do know this much, that deposition schedules aren't hard and fast. It depends on whether someone's sick, whether, what their schedules allow. So there's some movement there. If a deposition goes long, where two are intended to be done in one day, and a deposition goes long, then that might result in someone's deposition being taken another date, that type of thing. But the intent currently is to close that by the end of this month. There's another status report due in May, May 2nd or 3rd. And I know discovery on this matter closes on June 28th. Not just depositions, paper discovery, interrogatories, the back and forth that would typically.
And that was in the report, I believe, that we received.
That, I don't think
thought.
it was in the report, those dates, but I think I provided them to you in a separate email.
Okay.
So that's where we're at. The litigation matter is in progress. And that's all I can really report on that. And therefore, rather than come back month to month, I think it makes sense to
I'm
look
sorry.
back another 91 days.
What was the date that you said discovery will be completed?
June 28th, unless either party seeks an extension of that date, which is possible. But right now it's set to close on June 28th, and I believe the court has this matter on a fast track as far as courts put papers on fast track.
Okay. Okay. Well, out of respect for the people that showed up tonight, I do have to at least ask the board if they have any questions they have for you this evening. Doug?
No questions.
Okay. Doris?
No questions.
It's just, to me, it's always about, I don't have a substantive problem with the continuance, but I do want to just try to see if we can get this matter moved on. There is definitely a position that I have, whereas there's the recorded document with the abutters, and that was a prohibition on us hearing anything. And again, we've kind of covered that. And so to me, it's a little bit of circular reasoning, like we're continuing something that probably shouldn't be before us, but I've already discussed that at length. So it's a situation where I don't have a problem with the extension. I haven't heard anything in opposition. from the abutting councils on this extension. I read the status report with respect to the depositions. And so to me, at least that's been moving forward. So that's more of a, not really a question, more of a comment.
Yeah.
Mike, I do think we received a letter from
We
the,
did.
we did receive a letter. I thought the tone of the letter was, why have we not declined or declined this application? Because the application isn't complete, because the application doesn't have a, you know,
Yeah.
yeah, because the application has an open covenant
Oh, yeah.
on the property, and then, right, but no, and, and that was brought again today in an email that, or email with a letter that was attached to it. But my understanding at the time that we made the decision to do the continuance was we'd end up in front of appeals. Maybe someone could correct me on that. And that's how we ended up where we are right now.
Yeah.
So
I mean,
that's
that was exactly what we spoke about
right. So,
earlier.
I'm hearing it again today, but we'd not hashed, but we'd given it consideration. So I don't know if I'm going to feel comfortable
Changing course.
changing course,
Not a
although,
lot.
yeah,
I just-
okay. That's what I'm trying to feel. for.
I just
Mhm.
wanted to make sure is,
Mhm.
I had read the status report as well. It looks like it's moving through the system. I just continuations
Right.
forever. But
Okay, yeah.
yep,
I think
I'm with you.
I understand.
We've already kind of charted this course, so I'm.
Right.
Right.
Excuse me, I put myself back on. So, well, we charted the course and I was comfortable with the decision then.
Mhm.
I don't like the
Yeah.
extensions at all,
Yeah,
but I was uncomfortable with the decision, but I do think we'd be back in the other direction
agree.
with an appeal on it.
Yeah.
Not extending it.
Understood.
Hi, Howard Rose, Two Bantry Road. Thank you for hearing me. I was the one that wrote that letter. Respectfully, I disagree and I'm disappointed with your decision. This project was, if you read the letter of the application from Mass Housing, they clearly put it back. They didn't discuss it. They put it back in your court to discuss the legality of it. At that meeting, you agreed and decided, unless something's changed, that it was not appropriate to be in front of this board because it was still in court, and until that was solved, it shouldn't be. I apologize, I missed last meeting. We keep kicking it down the road, and I have to
Yeah.
ask, what does the town get from this? It's clear what the developer gets. State
So,
line on a 40B,
yeah, if I can,
please.
just because, again, I share some of your concerns. I shared some of the concerns when this first came before the board. I shared it really again at the second meeting. And I've had a number of conversations, both in person, on the phone and electronic with town council on this. It is, we don't have a lot of what I think are good options from a board. We could have rejected this outright, but then there's potentially some liability there for the town and the board as
May I
well.
interrupt you? Just ask, me,
Yep.
what is that liability?
That we would forego some of our rights, what limited oversight we have over that 40B, if we allowed to not hear that. And let's just say it was adjudicated that that agreement doesn't stand. It's not valid. Let's say the agreement's not valid. And so what it did would put the board by not, and here we are, we've pushed it back. We've allowed this to go, to let through the courts. We didn't allow the petition to move forward until we got clarification on that point. But this was the decision that we made as a board based upon the opinion of town council, based upon the opinions of both, we've had input from the signatories, their attorney on this as well. So
So you can see my challenge with this, that Mass Housing set this in motion by approving it, saying that we have no authority to look at the other stuff. We're just going to fund and sent it back to you for that. And that's not really the case, because now we're saying, oh, because they funded it, we have to go forward. And that's not what was said in their letter. Council, even our council at the meeting said that this would go back to land court. The worst they could do is say, no, hear it and move forward.
I agree with that.
So all they're going to say is, all we're doing is sending it back to have them send it back again. That protects the town. We have 2 other 40Bs coming to town. We don't need a third. The economic disaster of a third one, plus you're thinking you're going to add the MWTA thing. is a disaster for our town.
The merits, the pros, the cons, all of it,
Yep,
those are all separate arguments. For tonight,
but
it's
you're
the
here
extension.
for the town.
I hear
You're
you.
here for the developer.
I,
Developer is winning here because they're staying in line on a 40B. If they want to stay in line for the 40B, there's another avenue. They can do it based on the agreement that's there. They could build based on that, throw out the lawsuit, save them money. They're costing residents in this town money by dealing with this lawsuit. And they could build based on what they agreed to. Because they want to go back on their word is not a reason this should go forward. And because town council is worried he might have to do a little more work and go back and fight this in another court, when we already said that they're just going to send it back. to us.
but the question is he's not a judge
No,
and we don't get those determinations.
Right, and if I could, we did talk exactly about this at a previous meeting, and Mr. Talman's viewpoint was that the appeal court could just decide, you know, they're gonna allow them to do what it is they're proposing to do, and we've lost any leverage. Now, that's his opinion.
That's right.
and that's
And he-
different from his opinion from the last time. So he's.
No, I respectfully disagree. I think he made it clear. And I think we also share the same frustration. We really don't want to be in this position either.
But you shouldn't have heard this case in the first place and you were forced into it. Once you opened it, you have the chance to close it. And by kicking it down the road, you're making it even harder and harder to close it.
But I think our only options now would be to deny, and that
Yes.
would put us in a bad position.
I disagree because the denial is based on outstanding litigation that isn't resolved yet.
Well,
That is a clear reason to do this. It even said so in the original letters that it was in your purview to do that.
I mean,
A letter from MassDOT put it back 100% back in your purview to kill it because that wasn't resolved. They said, we are not even looking at this because it's not in our purview. We kicked that back to you to resolve it. And you haven't resolved it. You've kicked it down the road in fear of what might happen instead of resolving.
I-
That's shameful.
Through the chair, I'd like to correct the record. That's actually wrong. Mass Housing looked at the issue very extensively. They had one of the attorneys representing the D. Michaelises briefed the issue extensively. They asked me to respond to that brief, which I did, in a 20-page letter. They weighed it and they issued the project eligibility letter. And all they said in the project eligibility letter was not that the board can kick it out or deny it, that the applicant, meaning us, should be prepared to discuss it. That's all the letter said.
Have you resolved it?
I'm sorry?
Have you resolved the issue?
No, it's.
No. So you have, that's shameful that you should be in front of this board. You're here only to keep
Well-
this place in line that you shouldn't have. There's through other 40Bs just to hold your place in line and keep a 40B.
With,
Either build it by the letter and then get rid of this lawsuit or step out of line and take your chances.
those aren't the only options, through the chair, respectfully.
Well, the chair has the option and the board has the option to reject this and do the right thing for the town. And yet we sit here again, kicking it down the road for another 3 months. It's been on for 3 months. Now we're going for 6 months. At the time we're done kicking this down the road, the grace period in the letter will be gone and we'll be right back to where we are. The current agreement has a lot of things in it that the town will have to renegotiate and go through again. Access, where the buildings sit on the house, all of this was done already. And you guys should be using that leverage. It should be built by that, or we're going to sit here for.
with all
another
due
6
respect, that's exactly what we asked them to do. They actually took a delay to consider that.
That's right.
Um,
That's what we asked for. But the delay has now been 3 months, 6 months. We don't have that decision there. We're kicking it down the road,
Right.
waiting for the course and delayed and delayed.
Yeah, I just,
Now is the time for them to actually make a decision to do that, or you should kick it out.
I can at least commit to you that this will be reviewed again in more detail with town council. But quite honestly, I'm going to take his advice on and his inputs on that.
I wish he was here tonight to
Right.
resolve this.
Right.
I can reach out, I guess, but
He's got a lot more experience at 40B projects than I do,
Mhm.
probably than most people here. So that's why I take his advice quite seriously.
And Howard,
Apologize
just so
if
you
I'm
know,
yelling. I apologize if I'm yelling. As you can tell, I'm a little frustrated. This has been 10 years.
I hear you.
We
but
understand.
I
You're,
can
you're,
tell you, I've talked to him no less than 4 or 5 times on this. Okay? This is not something I take lightly.
Yeah.
And I'm not accusing you.
No, I didn't take it that way. I
Wanted
you
to
take
be
it personally. It's
accused.
been a saga and I get it, but this is where I've kind of, for myself, have kind of, even tonight, I was emailing town council on this for
How long
advice.
do we kick it down the road?
So right now, we're talking about a 3-month extension.
And then is it another 3 months of session?
I-
Another 3 months?
Well, we're gonna have to- we're-
You're at a 2 out of.
I have to take what's in front of us today.
right. We can't really.
My only question is for us and the boards and the petitioners is July 3rd is right before July 4th.
Right.
But is that a thing? Because we'll probably observe the 4th of July anyway, so that probably won't be a mess from a scheduling perspective. You know what I mean? Like
Actually,
the holiday itself are we going to be open? Because it's the 4th.
that's true.
I think we would be.
Do you want,
So
I'm amenable to pushing it back, uh,
I don't care.
To the 10th?
to the following week, sure.
Yeah, and we might be remote.
That means.
we'll be closed on the 4th,
Okay.
but as far as I know, we'll be open on the 3rd.
No.
Push. Push. Do we don't have anything scheduled for the 10th already.
Very tired.
No, we have nothing scheduled.
Okay.
I just want to be conscious of,
Well,
I don't want to build a problem.
I want to also, push the commensurate time in which you have to close the hearing back. If we push it a week to the 10th,
Do we have a regular scheduled meeting July, what's the date?
That would be the 10th.
Oh, no,
No,
the,
regularly scheduled would be the 17th,
of June?
July.
No, I was thinking,
you
when,
want to?
do we have something in June, like the week before?
Twenty-six.
Can't do it.
Can't do it. Okay, all right, let me just make sure.
Do you want
Yeah.
to push it to your regularly scheduled meeting of the 17th of July?
Is that gonna skew, or is that gonna screw us over with any other dates or?
So that would, unless you wanted to also hear regular applications, because I don't know what's coming. And the filing deadline for July 17th isn't till June 1st.
Well, would it make sense to make that?
Question, could we, because we all want this done sooner than later.
Mhm.
It's really more or less pending on the outcome of the litigation.
Right.
So it's a little bit of cart and horse.
I heard
The
just
re-
not at a point at the end of June to hold it.
That's what I
We're not
mean.
progressing.
I don't
Right,
think
you're
so.
saying your
Well,
discovery should be
my
completed
upper
by the end of June.
I'm sorry.
You said the discovery would be completed by the end of June,
Yeah,
hopefully.
June 28th. So
So how much more are we gonna know in the first week of July?
as I said, lots of permutations can
Yeah.
result from discovery. And I'm not a professional litigator, so I'm not going to pretend to even tell you what could happen,
Want to
but
do it the 17th for now? Or just,
Fine with doing the
Works for me.
17th.
because, what I envision, let's say the litigation goes away by July 17th. I don't even anticipate in earnest giving a full-on
Presentation.
and getting back
that's what I
on
mean.
track. I think what would happen, let's say we reopen the hearing on the 17th.
Yeah.
I think we're back discussing peer review, who the consultants
Yeah.
are, getting this really repositioned again.
Mhm.
And that's notwithstanding what how the litigation might ultimately impact any
Correct.
changes to the proposal. I don't know. I don't
Right.
even want to suggest that might. be
Yeah, we just don't know. We just don't know.
So,
I-
so whatever happens on the following hearing, let's say look, a number of things could happen, right? I could be before you asking for another continuance. I could be before you saying, hey, the litigation's done, settled, done, whatever, behind us, let's get back on track.
Yeah.
The court, well, the court's not gonna decide by July,
No,
this matter.
no.
It is on the fast track. So it is conceivable that the court could, if
Mm.
this goes to outright litigation and trial,
Mm.
not outright litigation, that's a redundancy. If it goes to trial, it is conceivable that this matter could be completed by by this calendar year. As I said, it is on fast track. I would be lying if I told you what the court's going to do.
You know, Mike,
So.
for whatever, for the unfortunate times I've been in court, in tax court, or, this is gonna go a long time. I'm
I-
just,
I
I mean,
couldn't agree more.
no, it just,
It just is.
it's just what it's
Yeah.
looking like it's gonna be. We're talking,
And I know that's.
And
part
I'm
of my
listening to you.
frustration, That's part of my whole.
we're into next year. I
just-
mean,
I just, trust me.
no, we're
it
trust me, I'm not, it's not a trust factor, it's an is
No, it's-
factor, it's an is.
Rubs me wrong 6 ways to Sunday, but I just think that's the reality of the situation.
Mm. So I don't mind having it on the 17th, back to the point, because I think we're just gonna see
We just,
more delay. That's what I think.
We might, we
We
might
might.
not. I really don't want to pretend to suggest
No,
what.
I
could happen
understand.
by then.
Mm.
I really don't. As I indicated to the chair, all sorts of interesting things happen as a result of discovery.
Mhm.
You know, issues that you'd never even thought of come out of discovery. I think that we may, emphasis on may, have a clearer picture on where this is going by the close of discovery on June 28th. We'll certainly know all of the issues.
Mm, okay. So is there a feeling to push it to the 17th then?
yeah, that's my take.
So that would result in, that's 2 weeks. That would result in. And Larry, if you want me to write another letter, I'll do that, to adjust these dates. What was my original,
Well,
November 13th?
you'll probably get into the Thanksgiving holiday.
Oh,
later,
yeah.
right? So,
That would be
Another
November
holiday.
27th.
4th of July to the 27th, if you push it back a full 2 weeks. 28th is Thanksgiving.
Yeah.
Look, if we get to a point in which that's really a concern, you know, your end date for closing a hearing, we can figure that out.
okay. Did you have something you wanted to add?
Two comments. One, snarky, that your definition of fast track and mine are completely different.
It's the
Listen.
courts.
I understand, but
the court.
listen to what you just said. We're not even going to look at this for a year. When, I want you to go, I'm not going to change your mind for this meeting, obviously. I would like you to go for the next 3 months. And I want you to ask yourselves, when do the residents in the town's needs come before the developers?
With all due respect, I don't think we're putting the residents behind the developers. I think we'll all take your inputs quite
I
seriously. I
That's all.
committed to, no, your decorum is perfectly fine. I don't have an issue with that. But I mean, I think you are at least pushing us enough to say that that's something serious we should revisit again with Mr. Talman. I'm not
Please.
trying to dismiss it. I think we are in with certain respect, like dealing with what we have in front of us. As I
I
think you
understand.
might put
But
it.
my point is that we're kicking it down to the road where if it was just the only difference between kicking it down the road and waiting till this is resolved is it's still in line for a 40B, which only benefits the developer. Kicking it down the road to the point
Yeah,
where that court is done, or where the other legal battle is past that 2 years, the only thing it's done is benefited him from keeping
Yeah.
in line for a 40B instead of getting him to the back. Nothing else has changed in that timeline, except it gives them the advantage that we can't get 2 more and tell them we don't need the third. The only saving grace is for them. It does nothing for us. And rather than forcing the issue now of saying, go by the thing where you have everything resolved, there's traffic and all the other things. If you went by the existing agreement, he could build this summer, but we're not there.
I understand. Yep.
Yep, you
okay.
got it.
Thank you.
Again, that's my point of why it's benefiting the developer and not the town. That's all it's doing.
Okay, all right, thank you.
Make a motion to close the public hearing. No?
No, don't, we can't, we have to,
You're
we're
continuing.
continuing it.
Oh, that's right.
Yeah.
Damn it.
All right.
Sorry.
Oh, I almost got it.
I think it's more of the motion to continue.
To
to-
continue it to July 17th.
Yep.
With the, do we need to cite the new date for our?
Just say with the,
With the extension
The 27th.
to the,
We can recite that and I'll follow it up with a letter tomorrow.
Okay,
That'd be great.
perfect.
Okay?
okay,
so moved.
Second.
Second.
all right, Doug second.
11/27.
Okay, we have a motion to continue the hearing to July 17th, 2024 with the commensurate extension of the 180 days to November 27th, 24. Let me say thereabouts. I don't know if this Thanksgiving holiday impacts it. Those in favor, respond with aye. Those opposed, nay. Doug? Aye. Doris?
Aye.
Mike?
Aye.
Williams? Aye. So there, we have it moved.
Thank you.
Thank you very much.
And if anything happens.
Yeah,
in
I was just
month,
about to ask if something breaks,
Yeah.
let us know.
Absolutely.
Thanks.
I mean, I've intentionally kind of steered clear of the litigation and I'm letting them do their thing.
Mhm.
Because I'm certainly eager to get back on track with
Great.
Okay,
the hearing, so.
All right.
all right, thank you.
Thank you. Thank you.
We have nothing else on the agenda, correct?
That was
When's-
it.
When's our
I
next?
thought we
meeting?
had something else. Do we have minutes or anything?
No, we have no minutes.
No, we did minutes at the last one,
That's right.
This is it.
got them out of the way,
This is all we
so
got.
next
Took me
meeting.
the whole thing to get rid of that background on my.
For April, no, we know what we're
No new ones. So the only new one is for 120 Turnpike.
That's,
on the
that's on the
24th.
24th.
Yep, that's it.
And then nothing for May.
Nothing for me,
And it's submittals closed, right?
correct.
Okay.
So,
Make a motion to close the hearing,
adjourn.
adjourn,
Adjourn, yeah.
whatever. That's how tired, that's how tired I am.
All right.
That's it.
Doris,
That's what happens, that's what happens when you adopt a 2-year-old in your 50s.
50s, I want to be
Motion.
in my 50s, okay.
a motion to adjourn has been made with a second. Those in favor, respond with aye. Opposed, nay. Doug?
Aye.
Doris?
Aye.
Mike? Williams, aye. Thank you very much. That closes the meeting. Thank you, everybody.
Thank you.